Well, good evening, everyone. The little quiet amusement at the table is that you will understand that the court is a very economic place. It's administered by the Chief Justice with an eye to economy, and there is an automatic light system, and we were just waiting for it to go off. And Jenny is just ready to turn them on again. So if you get a momentary piece of darkness, there you are. Welcome everyone, anyway, to this annual oration, proudly organised by the Victoria Law Foundation. I chair the Victoria Law Foundation as nominee of the Chief Justice. My name's Hartley Hanson, and my task at the moment is simply to open the proceedings, and in a moment I will call on the Chief Justice of Victoria, the Honourable Anne Ferguson, to introduce the orator for tonight's very special occasion and say some words. I should mention, it's worth mentioning, that this annual oration has been held in this most beautiful room since 2005, delivered by a significant array of speakers as tonight, and on topics of interest to the community and which affect matters of importance that go to the nature and shape of our community. There are just a couple of housekeeping matters I should mention. One is, please turn off mobile phones if you check that, if you haven't already done so. Second is that this evening's proceeding is being recorded. It will be available for viewing on the Foundation's website. If anyone has any issue about being seen on the recording, speak to the Foundation staff. And the third thing is that following the oration, Her Excellency has kindly agreed to take questions on the subject, so you might care to think during the oration of any question that you would think it appropriate to ask. I'll now ask the Chief Justice to open proceedings and introduce the orator. Chief Justice.
I acknowledge the traditional owners of the land on which we meet today, the Wurundjeri people of the Kulin Nation. I pay my respects to their elders past and present. A very warm thank you to the Victoria Law Foundation for organising the Law Oration, and to Hartley Hanson for his role in leading that organisation as my nominee. Victoria Law Foundation's 2018 Law Oration will be delivered by Her Excellency Professor the Honourable Kate Warner AC, Governor of Tasmania. Before her appointment as Governor of Tasmania in 2014, Her Excellency had a distinguished career in legal research and teaching, with a particular focus on sentencing and law reform. She was both a professor and Dean of the Faculty of Law at the University of Tasmania, the Director of the Tasmanian Law Reform Institute. Her Excellency's research interests include sentencing and criminal justice, and her teaching interests included criminal law, evidence, criminology and sentencing. Since her appointment as Governor, she has continued her research in sentencing. Her Excellency's published research includes Sentencing in Tasmania in 1991 study, which has since become an indispensable tool for judges and magistrates. She is a member of the editorial boards of Current Issues in Criminal Justice, Women Against Violence and the Criminal Journal. She contributed to the annual sentencing review to the Criminal Law Journal from 1998 until 2014. Related to her role with Tasmania Law Reform Institute, she's written a number of papers and reports for the board. Sentencing and related issues frequently make news headlines. That is not news. The Victorian Jury Sentencing Study, led by Her Excellency, took a close look at jurors' views on sentencing. By surveying almost 1,000 jurors from county court trials, the study explored jurors' views on a range of issues related to sentencing, including severity, purposes, aggravating and mitigating factors, and sentencing discretion. Using jurors as a subcategory of public opinion, the study's findings challenge the perception that the community is looking for harsher sentences across the board and provide interesting insights into sentencing issues from a lay perspective. I welcome you to join us for the 2018 Law Oration to explore the results of this study and the implications for the criminal justice system. Join with me, please, in warmly welcoming Her Excellency Professor the Honourable Kate Warner, AC.
Thank you very much, Chief Justice, for that very warm welcome. And can I also begin by acknowledging the Wurundjeri people of the Kulin Nation, the traditional owners of the land on which the Supreme Court stands, and to pay respects to their elders past and present. And thank you, Victorian Law Foundation, for giving me the opportunity to give an overview of the jury study findings that, to my horror, I now realise that I've been working on for over 10 years, which includes the first study we did in Tasmania. I'd also like to take this opportunity to thank all of those people that have helped and supported the jury studies. Particularly in Victoria, we've had enormous support from the judges and also from the jury commissioner and from the court staff. And without their fabulous assistance, the studies would not have been possible. And I also need to acknowledge my co-investigators on the projects, particularly on the Victorian study, Emeritus Professor Ari Freiberg, who's here this evening and probably will interject, maybe, and of course will help me with the answers to the tricky questions at the end. Also, Associate Professor Julia Davis from the University of South Australia and my colleagues from the University of Tasmania, Dr. Helen Coburn and also Dr. Caroline Sporanovic. Caroline is a criminologist with excellent statistical expertise, which was a great, or has been a great help on these studies because, as our Solicitor General, or former Solicitor General in Tasmania has said, there are three kinds of lawyers, those that can count and those that can't. So Caroline has been indispensable. So what I have a written paper, which is far too long, but I will try to stick to as much of it as I can because otherwise I tend to waffle a little bit and it takes me too long to get through things. And I had a little look at how long this paper would take and it was something like 115 minutes or something, so I thought, no, can't do that. So I will just talk about aspects of it. I planned to start off, or the written paper actually starts off with a section on the relevance of public opinion, then talks about the ways of measuring public opinion in relation to sentencing, moves on to the approach that we have taken in our study, and then discusses the results, divided into various sections, looking at jurors' views on sentencing severity, the purpose of punishment and sentencing factors, jurors' views on a jury role, and also I thought you may be interested in their views on judges. So it starts with a discussion of the relevance of public opinion, and this is to give some kind of theoretical underpinning to the projects, which I think initially we thought we would just like to do this project, but obviously as academics we had to justify it in terms of theory. So I have a look at the various perspectives on the relevance of public opinion. And my conclusion is not the exclusionary approach, which is that public opinion on sentencing is irrelevant, nor do I embrace the idea that direct input of public opinion is a good idea, but rather that public input should be limited, indirect, and controlled within a professional system. And I think that probably, yes, so this is really the approach that we've taken with this study. I think to adopt an exclusionary approach to public opinion is unlikely to satisfy demands for harsher sentences. And also, I think to say that the matter is only one for experts is no longer acceptable. And it's a particularly weak position, I think, from which to contest the fact that the media, politicians, and their policymakers too often rely on their own perception of public opinion, or else very shallow assessments of it. So, having discussed those theoretical things, which I won't have time to go into, but you'll be able to read, I go on to talk about current methods for examining public attitudes, so media polls, representative surveys, focus groups, deliberative polls as well. And I just want to finish by noting that there is increasing interest these days in citizen juries or citizen assemblies by governments as a way of engaging the public in policy making and also trying to restore some trust in public decision making. So I think examples include the work of the New Democracy Foundation in Australia, which has been engaged to undertake a number of deliberative democracy exercises, including the use of citizen juries of randomly selected South Australian residents to consider the use of nuclear waste dumps. And also in Ireland, there's the work of the Citizens' Assembly, which was a randomly selected group of 100 Irish citizens convened by the government to consider 5 legal and policy issues between October 2016 and April 2018 of this year, and a lot of publicity has been given to those. I then do a little section on what is public opinion, because it's contested. What is the public? What is opinion? But then move on to discuss the method that we used in our study. So the basic method for each of our 3 studies, the Tasmanian study, the Victorian study, and the national study, which we haven't reported the results anywhere of the last study as yet. So the basic method was to recruit jurors after they'd found a person guilty, so after guilty verdicts, to ask them to take part in the study, to give them a survey which first asks them to choose the sentence that they think is appropriate for the offender that they've just convicted. Also asks them about their views of sentencing in general, and also some demographical questions which we needed to see how representative our group was. So that's stage 1. After stage 1, after the judge has imposed a sentence, we then send each of those jury members participating, a copy of the judge's sentencing remarks, together with another survey, a little booklet about sentencing, and also a data sheet giving them some sentencing data, in the Victorian case from Victorian Sentencing Advisory Council, about the usual sentences for that particular offence. And this second survey, after they've read the judge's sentence, asks them about the appropriateness of the sentence in their view, and then goes on to ask about aggravating and mitigating factors in the case, and repeats the other questions about their general views of sentencing severity. Then at stage 3, we did some interviews, 50 interviews of jurors in Tasmania, and we also did 50 interviews of jurors in Victoria as well. And then in the Victorian study and the national study, we have had a follow-up later survey 6 months later. And in the national study, we introduced some controls, but I won't go into explaining about that, because I think on one occasion I remember talking about the jury project, and I was talking about all the difficulties we had in setting it up and whatever, and some of the feedback was, get on with it and tell us the results. So I shall get on with it and tell you about the results. And I'm going to focus mainly on the results from the Victorian study. So first I want to talk about the sentence severity comparison. Our jurors preferred sentences more severe or more lenient than those sentences given by the judges. So comparing the jurors' sentences with the judges' sentences, we found that in Victoria, 62% of jurors were more lenient than the judge. This compares with 52% was our result in Tasmania, and nationally it was 58%. Then at stage 2, remember we asked them, having read the judge's sentence, whether they thought the sentence was appropriate or not. In Victoria, we found that 55% said the sentence was very appropriate and 32% said it was appropriate. So 87% saying the judge's sentence is appropriate. Another thing we looked at was whether the type of crime makes a difference. And we found that jurors were less likely to be more lenient than the judge in sex offence trials than in trials for violent offences and other. So it was 50% more lenient in sex offence trials, compared with 71% were more lenient in violent trials, which is interesting. Then we looked to see then, because obviously jurors were less satisfied with sex offence sentencing, we looked to see if the type of sex crime makes a difference. And here we divided sex crimes into sex crimes with adult victims, with victims under 12 and victims over 12. And we found that in the case of victims under 12, where the child victim was under 12, only 36% were more lenient than the judge, and 63% were more severe. So quite a difference with respect to sex crimes where the victim was a child under the age of 12. And type of crime also made a difference in relation to the stage 2 ratings of appropriateness of sentence. So in sex crimes with a child victim under 12, only 36% responded the sentence was very appropriate. Remember, 55% had said so across the board. And we also asked our jurors their general views of sentencing severity. So when we asked them this question, asking about sentencing in the abstract, the majority of jurors in the Victorian study, the Tasmanian study and the national study felt that sentences were too lenient for violent sex and drug offences and about right for property offences. So in Victoria, 83% said sentences for sex offences were too lenient, and for violent offences it was 73%. Interestingly, in Victoria there was little change at stage 2 in their general views about sentencing, even though many of them were realising that their sentence had been more lenient than the judge. So that was an interesting finding. They just stuck to their view that sentences are too lenient, particularly for sex offences and violent offences. So what are the implications of these severity findings? Obviously, they show a stark contrast between jurors' views in a particular case and their views about sentencing in general. When asked about sentencing in general, more than 70% are responding sentences are too lenient for sex and violent offences, even though most of them had suggested a more lenient sentence than the judge. I think jurors' sentencing preferences in real cases show that their views are much more closely aligned with judges than answers to general questions about sentencing severity suggest. And this finding of ours echoes findings of other studies, not using jurors in real cases, but using vignettes and other methods to try and find out public views of sentencing. So together, these findings really highlight the fact that top-of-the-head views or mass public opinion about the leniency of sentences really can't be taken at face value. Moreover, I think that the Stage 2 responses to the general questions show that the effects of increased information are very limited when it comes to responses to these mass opinion type questions, these mass general abstract questions. So when asked simple or abstract questions like this, respondents tend to recall stereotypical pictures of the worst kind of offender rather than thinking of the typical offender. So this biased process of recall has been labelled the availability heuristic. Questions about sentences in a particular case probe inner attitudes, but abstract questions about judicial leniency tap more accessible surface attitudes. So it's been explained that these surface attitudes are not based upon accurate information about sentencing practice, but really reflect broad anxieties and fears about the dangers presented by the contemporary social world. Or it's sometimes put a little differently, that they reflect expressive concerns such as the breakdown of family life or generational anxiety. I don't know if any of you have picked up Daniel Kahneman's book, Thinking Fast and Thinking Slow, which you often see in airports and is quite a widely read book. But this talks about System 1 and System 2 thinking, which is a similar idea. So in other words, if you are looking for informed public opinion or considered judgments rather than top-of-the-head responses, answers to mass public opinion style questions are not the right place to look. And we would argue that by engaging jurors in the task of deciding the appropriate sentence for an offender and then asking them about the appropriateness of sentence, we are really here eliciting informed judgment about sentencing. Of course, there's a question here about, is there a punitiveness gap between judges and jurors in relation to child sexual assault? Because remember, for this particular category, we found in Victoria that for child victims under 12, 63% of respondents selected a more severe sentence, and there was not a majority saying the sentence was very appropriate. So the results of the national study, which focuses on sex and violent offences, will help us unpick this a little bit more to see if we get the same kind of result in the national study. Just looking at our preliminary results, it looks as though you've got the same pattern of jurors being less likely to be more lenient for this category of offence, but at this stage we haven't got a majority being more severe as we had in the Victorian study. So we need to look at the results more carefully in relation to that. So now I want to talk a little bit about the jurors' purpose preferences and to compare that with the judges' purpose preferences. Because in stage 1 of the Victorian survey, after inviting the juror to nominate the appropriate sentence, we asked them to identify the single most important purpose that would be achieved by the sentence, and we listed in accessible language the list of statutory purposes from Section 5 of the Victorian Sentencing Act: retribution or desert, specific deterrence, general deterrence, rehabilitation, incapacitation and denunciation. And to allow a comparison of the jurors' responses with judges' preferences, we analysed the judge's sentencing remarks to determine the weight given by judges to the purpose of sentence. And I set out in a bit of detail how we did this. But to talk about the results, for judges, general deterrence was the most important purpose, but it was the least important purpose for jurors, whose most favoured purpose was retribution or just deserts. In the stage 3 interviews, we talked to jurors about what the judges had said about purposes and what they'd said, and we found that jurors' criticism of judges' reliance on general deterrence included a lack of evidence of the effectiveness of deterrence, and ineffectiveness because many offenders don't consider the consequences or know of the penalties. For example, Juror 173 said that general deterrence would really only work if you put sentences on a billboard in Fed Square every morning. We also found that judges generally prioritised incapacitation or protection of the public in serious offender cases where there was a statutory requirement to do so. Well, you'd expect that they would. But in these particular cases, jurors only did so for 1/5 of the cases, which was an interesting contrast. So, what are the implications of lack of alignment of judges' and jurors' purpose preferences? So general deterrence and incapacitation are two areas where there's a lack of alignment. Our finding that general deterrence was at the bottom of the list of jurors' preferences is not really surprising in the light of other research on the public's purpose preferences, including Geraldine Mackenzie's national study and also the Tasmanian Jury Sentencing Study, which also showed weak support for general deterrence. So judges are, of course, constrained by legislation and appellate guidance to place reliance on general deterrence, and if they fail to do so, this can lead to a successful appeal. But academics make a distinction between system deterrence and marginal deterrence. In terms of system deterrence, while it's quite clear that the criminal justice system as a whole has a deterrent effect, there's no empirical evidence that prison sentences of imprisonment deter better, or longer prison sentences deter better than shorter prison sentences. And I think it's quite interesting that some jurors shared this scepticism. There's also some evidence that some judges at least are sceptical of the effectiveness of general deterrence, but at the appellate level at least, judges tend to stick to the long accepted wisdom of the effectiveness of general deterrence. Now, academic commentators here and elsewhere have suggested a number of explanations for why judges cling to general deterrence, including, and this comes from Andrew Ashworth in the UK, that perhaps it's simply rhetoric or deterrence speak, a standard way of just expressing the wrongfulness of the conduct. Or alternatively, it's been said that judges who inflict punishment on offenders as part of their daily business really feel the need to believe that there's some compensating benefit behind criminal punishment. However, I think there's a problem with relying upon general deterrence in individual cases. I think it tends to encourage the populist belief that harsher penalties are needed to control crime, that there's a relationship between reducing crime and harsher penalties, of which there's very little evidence. So maybe our study provides some support for a policy in abandoning general deterrence as a purpose preference in individual cases. Certainly this was something that the ALRC suggested many years ago, and I think that fed through to the Crimes Act, where they didn't list general deterrence as a purpose, but the judges read it back in. So, also in relation to incapacitation, I think it's notable that jurors instinctively chose protection of the public as the primary purpose in only of the fifth of the cases which were caught by the serious offender regime. Statutory provisions which prioritise protection of the public over other purposes are generally justified on the basis of responding to community demands for harsher penalties, and they're politically attractive for this reason. But our research suggests that when individual cases are examined, prioritising protection of the public as a purpose is not necessarily something that the community prefers. So maybe it would be possible to scale back the serious offender provisions with their focus on incapacitation, and that may better reflect the values of laypersons. So, sentencing factors. This is a part of the study that I found really intriguing, and one of the purposes of the Victorian study was to compare jurors' views of sentencing factors with those of judges. So we did this by obtaining jurors' views at stage 2 after they've read the judge's sentencing remarks. And the first question in this section of the survey listed 8 common aggravating factors and 10 mitigating factors, asking the juror to give weight to them, no weight, a little weight, a lot of weight, or did not arise. So the 8 listed aggravating factors were offence-related and offender-related. So the offence-related factors were abuse of trust or power, victim vulnerability due to age or disability, substantial harm, and planning. And the offender-related factors, aggravating, prior convictions, offender on bail, parole, or in breach of a suspended sentence or community order. And then we had the 10 mitigating factors, all offender-related or personal mitigating factors, these are sometimes called, such as no prior convictions, good character, good prospects of rehabilitation, youth, old age, physical illness and impairment, and so on. And respondents were also asked or given the opportunity to add any other factors that they thought were aggravating or mitigating. And we had a separate question which related to 4 other factors, which we termed ambiguous factors, which may either be aggravating or mitigating. So mental disorder, intellectual disability, drug addiction, and intoxication. So our plan was to get judges to fill in a form at the same time as they completed their sentencing remarks, which listed the same lists of aggravating and mitigating factors as we gave to the jurors. So some judges did this, but unfortunately we only received forms for some 30% of the offenders in the study. So that wasn't enough for a good comparison. So we had to use pseudo-judges, it was us. So we had to look at the judge's sentencing remarks and code them. So for each offender we had 2 people doing this, we compared them, and we also used an in vivo analysis coding the relevant parts of the sentencing remarks to try and make sure that we were acting consistently. What did we find? Well, we found that judges and jurors were alike in giving more weight to aggravation than mitigating factors. And for aggravating factors, a majority of judges and jurors gave each of the listed offence-related aggravating factors a lot of weight, so they were reasonably similar there. And a majority of judges and jurors also gave at least a little weight to the listed mitigating factors where they arose. However, jurors did give less weight to these mitigating factors than judges, notably to good character, being a first offender, old age, physical illness, and family hardship. For example, in cases where the judge had identified the offender as old, and we quickly realised that these questions were quite subjective, but this was basing this on the judge's assessment of whether or not the factor arose. We found that 38% of jurors gave this no weight, in contrast with judges who gave old age no weight in only 5% of cases. We found similar results for ill health, jurors being less likely to give these factors mitigating weight than judges. And I think M's case illustrates the difference between the approach of judges and jurors to good character and being a first offender. So M was convicted of aggravated burglary and kidnapping. The sentencing judge gave a lot of weight to the fact that he was a first offender and of good character. We interviewed 2 jurors from this trial, neither of whom had given any weight to these 2 mitigating factors. And juror 882 explained why she gave no weight to good character and being a first offender. She said, "I think in this case, because it was so unprovoked, and who cares if he was a good family man? He beat the crap out of a guy with a baseball bat for no good reason whatever. So quite frankly, I don't care if he's great to his kids." So the reluctance of many jurors to give weight to old age is illustrated by the response of Juror 6. Juror 6 said, "Well, hang on, it doesn't matter whether he's 25 years of age or 75. If he's involved in a crime of this magnitude, and it was conspiracy to import drugs, he should pay the punishment." We found that jurors were a little more likely to give a lot of weight to family hardship than judges. And we found that when judges gave this weight, they rarely gave it a lot of weight, which is not surprising in the light of the sentencing law, but quite often they gave it a little weight. But they did so not on the basis of direct hardship to the family, but on the basis of the effect of knowing about hardship on the offender. So indirectly, this was considered relevant. However, the jurors, when they treated it as mitigating, they did so on the basis of the effect of hardship on the family, not the effect on the offender of knowing about this hardship. We also found that jurors tended to adopt a broader interpretation of some aggravating factors, such as breach of trust. So for those cases identified by the judge as giving a rise to a breach of trust, judges and jurors gave it similar weight. However, jurors regarded it as relevant and aggravating in a broader range of cases than did judges. For example, in cases where a sexual relationship had ended and there was violence, and also in cases too of date rape. We found a bit of conflict between the judges in these cases. Some judges regarded date rape as a situation where there was a breach of trust and others didn't. And there is some appellate guidance suggesting that this is not a breach of trust situation. Delay was another interesting finding, and this surprised us. When we analysed the sentencing remarks, we found that delay was relied upon by judges as a mitigating factor for 46% of the offenders in the study. So this made delay the most common mitigating factor behind good prospects of rehabilitation and good character, and ahead of being a first offender. And in most cases, we coded this as some weight, this factor, rather than a lot or a little. Now, we hadn't listed delay in the list of mitigating factors on the judges' forms or in the juror surveys. And the question which asked for additional mitigating factors talked about factors which reduced the seriousness of the offence. So that wasn't really an appropriate question to pick up system considerations like delay. So for this reason, it's perhaps not surprising that few jurors actually included it in their forms. And the interviews gave us an opportunity to ask jurors about this factor. And when we pointed out the judge had relied upon it as a mitigating factor, their responses were mixed. Some agreed with the judge, some did so when we explained the judge's reasons for doing so, and some were sceptical, and some just disagreed with making delay a mitigating factor. So ambiguous sentencing factors. So these were mental disorder, intellectual disability, intoxication, and drug addiction. Here we found that judges generally found mental disorder and intellectual disability to be a mitigating factor, 83% for mental disorder and 70% for intellectual disability. And we found that the fifth Verdun's principle, which mitigates on the basis of a more onerous effect of imprisonment on the offender, this was the most often engaged principle, followed by principle 6, which is the situation where there is a significant risk that imprisonment will make the mental disorder worse. And we found mental disorder and intellectual disability aggravating in just one of our cases. And comparing judges' responses with jurors, we found that where the judge had indicated the offender had a mental disorder or cognitive impairment, jurors' most common response, surprisingly, was it did not arise. Mental disorder was said to be mitigating by jurors in only 19% of the cases where judges said the factor arose. So this compared with 83% of judges saying it's mitigating. So here we've got a difference between judges and jurors. And we found judges were twice as likely to say that an intellectual disability was mitigating than jurors. So the interviews supported the inference that many jurors adopted a narrow view of what amounts to a mental impairment, and also suggests that jurors weren't persuaded that the sentence should be mitigating because a mental disorder made imprisonment more onerous. So they weren't persuaded by Verdun's principle number 5. We also found that jurors were more likely than judges to find substance abuse relevant, particularly intoxication, where a majority of jurors responded that it was aggravating, compared with only 14% of judges. So here again, a difference. We found from the interviews that jurors said intoxication was aggravating in cases of sexual assault and domestic violence, in cases where the judge had found it neutral or even mitigating. So, what are the implications of the findings in relation to sentencing factors? So I think there are 2 reasons for looking at this. I mean, I found it intrinsically interesting, but that's not enough. You could say that these sorts of findings are relevant when there's a review in relation to sentencing factors by a law reform body or a sentencing body. And also, it's interesting, I think, to alert the judiciary to the need to clearly explain why certain factors are treated as they are, where we've got a mismatch between jurors' views and the judges' views. So the first headline finding, I think, coming out of looking at relevant factors is that jurors are not generally averse to factors of personal mitigation, even though they gave them less weight than judges. And I think this shows that jurors like an individualised approach to sentencing, and it's another corrective to the idea that lay members have a punitive response. So I think that can be used in that way as well. The findings in relation to mental disorder and intellectual disability are worrying, I think, because of the contrast between judges and jurors and the divergence between judicial and juror views. You know, the fact that so few jurors thought that a mental disorder or intellectual disability was mitigating is striking. And this seemed to be because many jurors just did not recognise many of these conditions as being a mental disorder. So conditions or diagnoses like severe depression or post-traumatic stress disorder weren't regarded by jurors as a real mental disorder, we found in the interviews. I think this is a finding which has very worrying implications in terms of public mental health literacy. And I think it's also concerning that jurors seem to be reluctant to accept impaired ability to exercise judgment as a basis for mitigation, and the fact they were demanding a stronger link between the condition and the offence. Impact mitigation, I think, is an interesting area. A consistent finding across a number of mitigating factors is the tendency for many jurors to be unpersuaded that a factor is mitigating if it makes imprisonment harder to bear. Judicial sentencing practice treats a number of conditions or factors as mitigating on this basis: old age, physical illness, mental disorder, intellectual disability, and the effect of family hardship on the offender. This lack of support for impact mitigation emerged in the interviews as one of the reasons why jurors gave less weight to mitigating factors than judges did. Now, I go into this in a bit of detail in the paper, but I think from a normative perspective, it's preferable to give weight to mitigating factors on the basis of a principle like equal impact mitigation, rather than on the basis of mercy, because of mercy's attendant potential for inconsistency and discriminatory application. So Verdon's principles 5 and 6 can be justified on this basis, and I think given the principled basis for mitigation on this basis, then this is not an area where I'm suggesting we change the law. But I think the lack of alignment does suggest that it's an area where judges need to be very careful in explaining this ground of mitigation and be aware of its lack of appeal to members of the public. I know that in some of the sentencing remarks, judges would just say, mental disorder is mitigating on the basis of Verdon's Principle 5. Well, that's not very helpful to a layperson in understanding the sentencing remarks and why mental disorder should be mitigating. So I think it's better to spell it out and make it clear to a layperson why this factor is mitigating. I also, in a paper, talked quite a bit about the difference between judges and jurors in relation to family hardship. And again, that was an interesting finding for me. I expected judges not to give weight to family hardship, not even to give it a little weight. I was surprised to find that they so often gave it a little weight on the basis of its effects on the offender. So I thought this is quite interesting. Family hardship is quite, family dependence and the effects of imprisonment on a family is quite a controversial factor, and there have been arguments that we should drop the rule that it can only apply in exceptional cases. So there's an argument, there are quite good arguments for saying there's a principled basis for family hardship, which I go into as a mitigating factor. And again, it would seem that there's some public support for regarding this as mitigating on the basis of its effects on the family rather than on its effects on the offender, rather than on the basis of impact mitigation. I also ask whether or not we should take a broader view of breach of trust. This is perhaps an area which could be thought about. Jurors found it aggravating in date rape situations, and also where it was a relationship or an ex-relationship kind of scenario. So should breach of trust be extended to cover this kind of situation, I think is worth thinking about. I've also got a section on whether or not jurors wanted a greater role in sentencing, and I haven't got time to go into that, but there's a paper coming out shortly on this particular point, and I can just briefly say that in general jurors did not want a role in deciding the type and length of sentence. They thought the judge was the best person to choose an appropriate sentence. Are judges out of touch? It's often claimed that judges are out of touch with what ordinary people think, and this is often made in the context of demands for harsher sentences. This causes concern to judges because propagating such reports has an impact on confidence in the criminal justice system. So there are often surveys that ask this question. The British Crime Survey in several sweeps has asked, are judges out of touch? 80% tended to respond judges were out of touch with what ordinary people think. And in the 2009 National Public Opinion Survey in Australia, 58% disagreed with the statement that judges are in touch with what ordinary people think. So in other words, majority think judges are out of touch. But in the Victorian study, rather than a majority disagreeing with that statement, only 25% did so. And in Tasmania, only 29% thought that judges were out of touch. And it was interesting that when we interviewed jurors about this, those that had said judges were out of touch said, well, that's not a bad thing because the public don't know anyway, so they shouldn't be in touch with what the public think. So, to conclude, I think that the responses to the question about the juror's sentencing choice, the question about the appropriateness of the sentence, about aggravating and mitigating factors and a jury role in sentencing, all support the conclusion that jurors, as informed members of the public, are not clamouring for heavier sentences, that they can support individual sentencing decisions, personal mitigation, sentencing discretion, the judge is the most appropriate person to sentence, but at the same time still hold the view that in general sentences for violent crime and sex crimes in particular are too lenient. So these general questions, these abstract questions, tend to tap into surface feelings rather than informed and thoughtful judgments. As Juror 522 indicated when explaining her apparently contradicting responses, coming up with a more lenient sentence than the judge, but still saying sentences are too lenient in general, she said, I do feel everything is a bit lenient these days. Society is out of control. So it's tapping into a different state of mind. It's not really asking that question. It's asking the question, but it's not getting an answer to the question. Comparing the views of judges and jurors in relation to purposes and sentencing factors, I think revealed some areas where there's a mismatch between judicial and juror views. And I think this can possibly also indicate a misalignment between judicial views and members of the public. Results which would contribute to sentencing debates include anchoring points for child sexual assault, which we've got to look at again, jurors' preferences for expressive purposes of punishment over general deterrence, the scope of breach of trust as an aggravating factor, and the relevance of family hardship. I think that the mismatch between judges and jurors with respect to impact mitigation in particular suggests that this is an area which would benefit from better explanation by sentencing judges in their remarks. And I didn't have time to go into this too, but I think the analysis of sentencing remarks indicated that in some areas, such as substance abuse, this is an area which would benefit by better appellate guidance. Our study supports that, and I go into that in a little bit more detail in the published papers that have come out from this project. Whoa, I did it in 50 minutes. So thank you so much for listening, and I think now I've got the opportunity to answer some questions.
Well, I think, Your Excellency, you have been very generous with your time, and a lot of questions. You've put an enormous amount of work into that paper that's still coming along. So thank you very much. We've been very fortunate, I think. And may I also say to you, Chief Justice, thank you again for allowing the Victoria Law Foundation to hold the oration in this courtroom, this lovely historic courtroom. To the staff of the Victoria Law Foundation, thank you for organising the whole evening, and thank you all for coming along on such a rainy night, and travel safely home. Thank you.